A very good afternoon to all of you. Today we are going to discuss about the concept of foreign court, foreign judgment, and res judicata. Before going to explain the same, I would like to recapitulate what we have done till date. We have discussed the meaning of Code of Civil Procedure and also have studied the historical background of Code of Civil Procedure as well as some of the important steps or oblique definitions which played an important role in instituting a civil suit in a court of law. And today we are going to start with our new topic. That is foreign court. What do you mean by foreign court? Section 2 clause 5 of the CPC defines the same, and following two conditions must be satisfied in order to bring a court within the definition of foreign court. First, it must be situated outside India. The court must be situated outside India. That is the foremost condition. And second condition is it must not have established or continued by the central government. If the said court is governed by the central government, then the same would not come under the definition of foreign court. Now the next concept is, what do you mean by foreign judgment? Foreign judgment is defined under section 2 clause 6 of the CPC. It means a judgment of a foreign court. So these are the definitions of foreign court and foreign judgment. Now I would like to explain the doctrine of res subjudice. What do you mean by doctrine of res subjudice? It is defined under section 10 of the Code of Civil Procedure. It provides that no court shall proceed with the trial of any suit in which the matter is also directly and substantially in issue in a previously instituted suit between the same parties, and that the court in which the previous suit is pending is competent to grant the relief claimed. The rule applies to the trial of the suit and not to the institution thereof. It also does not preclude the court from passing interim orders, such as grant of injunction or stay, appointment of receiver, etc. Now the next question is to be read is, what is the object behind res subjudice? The object behind this particular doctrine is to prevent the courts of concurrent jurisdiction from simultaneously entertaining and adjudicated upon two parallel litigations in respect of the same cause of action, the same subject matter, the same parties and the same relief. And the section intends to prevent a person from the multiplicity of proceedings and to avoid a conflict of decisions. Next, what are the essentials of doctrine of res subjudice? As you all are aware that for coming or following a case under this particular doctrine, some points needs to be satisfied. So these are the following a case with regard to whether the case would fall under the category of doctrine of res subjudice or not. There, before that, essentials of doctrine of res subjudice are there must be two suits, one previously instituted and the other is subsequently instituted. The matter in issue in the subsequent suit must be directly and substantially in issue in the previous suit. Both the suit must be between the same parties or their representatives. The previously instituted suit must be pending in the same court in which the subsequent suit is brought, or in any other court in India, or in any court beyond the limits of India, established or continued by the central government or before the Supreme Court. Next, the court in which the previous suit is instituted must have jurisdiction to grant the relief claimed in the subsequent suit. Next, such parties must be litigating under the same title in both the suits. So these are the essentials of doctrine of res subjudice. Now the question is, what are the exceptions to the rule of res subjudice? The first exception is that this rule does not apply to the suit which is pending before a foreign court, and it also does not apply to interim orders such as injunction, stay, appointment for the local commissioner, etc. and etc. Now, the next question which is also relevant herein is that what is the effect of contravention? The answer is a decree which is pending in contravention of section 10 is not a nullity, means that is not void, and therefore cannot be and therefore can be executed in therefore it can be executed and it can be looked upon by the executing court also. Next, what do you mean by doctrine of res judicata? Res judicata means it provides or it lays down the rule of conclusiveness of a judgment as to the points either of fact or of law in every subsequent suit between the same parties. Under the Roman law, it was said that one suit and one decision is enough for any single dispute. In Satyadhan Ghoshal versus Dio Rajan Devi, EIR 1960, Supreme Court 590, held that the principle of res judicata is based on the need of giving a finality to judicial decision. Now, what is the object behind this particular doctrine? This doctrine is based upon a legal maxim, nemo dabit vis vixari pro una et idem causa, means no one should be vexed twice for the same cause. Now the next point, next relevant legal maxim is interest republicae ut sit finis litium. It is in the interest of the state that there should be an end to the litigation. In Corpus Juris, volume 34, page 743, res judicata is based upon two grounds. First is public policy and second is necessity. Now I would like to give an example with regard to doctrine of res judicata. A sues B for damages for breach of contract. The suit is dismissed. A subsequent suit by A against for breach of the same contract is barred A's right to claim damages from B for breach of the contract having been decided in the previous suit, therefore it becomes res judicata and cannot therefore be tried in subsequent suit. Now, the next relevant question which is to be dealt herein is that what is the difference between res judicata and res subjudice? Res judicata applies to the matter already adjudicated upon, whereas res subjudice applies to a matter pending trial. Res judicata bars the trial of the suit or an issue which has been decided in a former suit. Res subjudice bars the trial of a suit which is pending decision in a previously instituted suit. Now, what are the essential conditions for the application of this doctrine? There are five essential, and the first essential is that the matter must be directly and substantially in issue in the subsequent suit, or it must be the same matter which was directly and substantially either actually or constructively in issue in the former suit. Second is the former suit must have been between the same parties or between under whom they or any of them claim. Third point is such parties must have been litigating under the same title in a former suit. Fourth point, the court which decided the former suit must be competent to try the subsequent suit or the suit in which the issue is subsequently raised. And the last point is the matter directly and substantially in issue in the former suit must have been heard and finally decided by the court in the former suit. So these are the five essentials of res judicata. Now we would like to have certain case laws and also what is the relationship between res judicata and PIL, what is the relationship between res judicata and writ of habeas corpus, and what is the relationship between res judicata and criminal proceedings. As far as civil proceedings, you are aware that under section 11 the res judicata would be applicable to the civil proceedings. But with regard to criminal proceedings, there is a case that is Bhagat Ram versus State of Rajasthan, EIR 1972 Supreme Court, wherein Supreme Court has held that after looking into the governments of the parties and the law laid down under section 300 of CRPC, court took the view that yes, it would be applicable. The principle of doctrine of res judicata would be applicable also to criminal proceedings, like in the case of civil proceedings. Now, next question is whether the doctrine of res judicata would be applicable to writ of habeas corpus. Answer is no. In the case of Daryao Singh versus State of UP, the court says no. Why? Because the writ of habeas corpus is related to right to life and personal liberty of an accused. As such, that his life can only be taken after taking into due process of law or the procedure established by law. Therefore, this particular writ has been given an exemption from the applicability of res judicata. Now, the next question is whether this doctrine of res judicata would be applicable to public interest litigation. Answer is yes. This was so held in the case of Forward Construction Company versus Prabhat Mandal, 1986, 1 SCC, page number 100. Now, we will look into the relationship between res judicata and foreign judgment. Section 13 and 14 of the Code of Civil Procedure annex a rule of res judicata in the case of foreign judgment. As per Section 13, principle of res judicata would be applicable on foreign judgment except in the following cases. So, general rule is yes, it would be applicable, but if any of the following conditions would be satisfied, then the principle of res judicata would not be applicable. Under what these circumstances are: foreign judgment was not rendered by a competent court. If the foreign court is not competent to decide that particular matter, then the decision rendered by that particular court would not be binding upon the Indian court, and therefore the principle of res judicata would not be applicable. Second, foreign judgment which has been rendered by the court, by the foreign court, has not been given on merits. It has decided on the preliminary grounds, like dismiss in default. So, if that would be the case, then that decision would also not be binding on the Indian courts. If the foreign third point is foreign judgment against the international or Indian law, if it is if the judgment rendered by the foreign court is against the law laid down by the law laid down under the international law or by the Indian law, then also the same would not be applicable in India. If the foreign judgment has been given by the foreign court and the same is opposed to the principle of natural justice. As you all are aware, that principle of natural justice includes right to audi alteram partem, right to opportunity of being heard. So if these principles are not followed, then also in that particular case, that judgment would not be binding in India. Next point is, when the foreign judgment has been given or obtained by the party by fraud, if the person who has invoked the foreign court jurisdiction and thereby got a decision by fraud, then also that decision would not be binding in India, and the doctrine of res judicata would not be applicable in this case. Next point, foreign judgment founded on breach of Indian law. If the judgment rendered by the foreign court is in contravention to the Indian law, then also the same would not be applicable. So these are the 6 grounds on the basis of which we may say that the foreign courts would not be binding, or the doctrine of res judicata would not be applicable on these judgments. Next point is, what is the presumptions as to the foreign judgment? Section 14 of the CPC, or the Code of Civil Procedure 1908, provides the rule regarding the same, and it says that the presumptions as to the foreign judgment is a rebuttable presumption. What do you mean by rebuttable presumption? Rebuttable presumption means the presumption which can be rebutted on the evidence on the evidence contrary to the facts may be given. Then in those circumstances, rebuttable presumption would be applicable. Now I would like to go further. This is what we have to discuss today in today's lecture. Hope you have learned a lot from this lecture. In case of any query with regard to today's lecture, you may write to me on my email ID, that is rahularora.gn@jagannath.org. Now, I would like to let you know what we will be going to discuss in my further lectures. In my next lecture, we are going to discuss the following topics. The topics are caveat, restitution, inherent powers of High Court. These 3 topics would be dealt by me in my subsequent lecture. Hope you have enjoyed this lecture and also learned from it. Hope you have a good day ahead. Thank you very much.